Anyway, welcome everybody. Jacob was very, very nice introducing me. Only 30 years experience. It's probably been closer to 40 now. But anyway, I am going to concentrate on the tax side of things because that's what I do. And when you talk about estate planning, there are so many different other considerations. Every family's different, every person's different, everybody's goals are different. So it's very, very important that you are working closely with an attorney on this that will draft your documents and make sure your concerns are the non-tax considerations are taken care of as well. I mean, there's all kinds of special situations, special needs trusts, family members with it's just very, very important. Generally your practical wishes are more important than the tax consequences. So currently, for estate tax planning purposes, everybody gets a unified credit. And by unified, they're talking about the fact that gift and estate taxes are considered together. So you've got a lifetime amount that you can either give while you're alive or give at your death. It's a transfer tax. So, you look at when the assets actually go from one entity to another entity. Currently, for 2024, the unified credit for your lifetime is $13.6 million. So currently $13.6 million, that's everybody, each individual. So a married couple now has, $27.2 million that they can give together. So that's a lot of dollars and a lot of wealth. And at this point today, a lot of people don't need any estate tax planning considerations because the 27 million is a lot of money. And most people won't even have to worry about estate and gift tax. However, that is scheduled to be cut in half as of January 1, 2026. And this is an automatic thing. The exemption was doubled in the 2018 TCGA, and it was scheduled to sunset as of 1/1/26. So unless action is taken, it's going to be cut in half, which means suddenly it's $13.6 million for the couple instead of $27 million, and that brings in a lot more people that have got to worry about it. So one of the strategies, the IRS has said that if you go over, use the full current amount, and then the limit gets reduced later, like it's scheduled to be, then they were not going to claw it back. In other words, if you gave it and it was tax-free when you gave it, it's never going to be taxed. So I anticipate doing a lot of gift tax returns for 2025. People that are in that, $7 to $13 million of wealth right now, or will be in the future, probably need to go ahead and use this higher exemption amount because it may not be there in the future. Sort of a use it or lose it type situation. And because it's scheduled to sunset, it's going to take congressional action to change that. And I think we all know right now that we don't have the most functional Congress in the world. And for them to take action, even if everybody agrees, is not always going to happen. And if it does happen, a lot of times with these tax things, they won't get around to doing the change until December 31st of 2025. So you won't know in advance that you don't have to gift. So I think a lot of people are going to be conservative and go ahead and do the gifting during their lifetime to use it up and not lose it. The exemption amount is portable between spouses, which means that if somebody dies and has not used their full $13 million, you can file an estate tax return, and that effectively, report their less than $13 million of gross estate and show how much of their unused exemption is transferred to their surviving spouse. So the kickers there are that, yes, you have to file the return. And generally you need to have values for your assets. The valuation restrictions or requirements are not as strict for an estate tax return for portability only purposes as they are for one that's going to have taxable estate. So the 13 million scheduled to sunset and the portability are the important factors for your unified credit. Maximum rate is currently 40%, and that's above and beyond the exemption amount. So if you've got a $15 million estate and you die, only the amount above and beyond the 13.6 is taxable. But at a 40% rate, that still adds up pretty quickly. And one of the issues, especially for small business owners or for business owners in general, is that, you've got to have money to pay this tax. So even if the tax is only, say you've got a $20 million estate, less the 13.6 exemption, that gets you $7 million of taxable. And it's, about 2.9%, $2.9 million in estate tax. Well, you're saying, fine, I've got a $20 million estate. But what if that $20 million estate is all tied up in your small business? Where do you get the funds? So that's another consideration, even if the amount of the estate tax doesn't sound too bad, is make sure you're liquid enough to be able to have the funds to pay it, and not have a hardship and have your heirs having to sell things. So the gift tax exclusion, these are some other basic rules that are out there. Right now, everybody can give $18,000 to as many different people as they want every single year. It's got to be a gift of a present interest. And there's some hoops you jump through if you're using a trust to make sure it's a present interest. You give the donee a right to withdraw from the trust that they never exercise, but that makes it present. And then another thing that a lot of people, for educational purposes will take advantage of is the unlimited educational and medical exclusion. And the kicker on that one, the requirement is that you've got to pay the institution directly. So if you've got a grandchild that's in college and their tuition is, $30,000 a year, you can't give the parent $30,000. You can't give the kid $30,000 to be used for that purpose. You've got to write the check to the college. But all these are great ways to get money out of your estate. You start doing this early and often, and you can move a lot of wealth. Basis step up. And by this, I mean, so the recipient of a gift or a bequest, they've got their basis in the asset. So if they turn around and sell it, that basis is used to determine whether they've got taxable gains or not. And so there's a big difference here between assets you receive at death and assets you receive by gift. If you receive an asset by gift, you do not get a stepped up basis. In other words, whatever the donor's basis is, that is the recipient's basis as well. So that can come into play with highly appreciated assets. So say you've started your own business, you put a lot of sweat and tears into it, but not much money, so you don't have much basis in it, and it's worth a lot of money. If you give that to your heirs during your lifetime, and then turn around and sell the business, there's a large taxable capital gain. Whereas if you wait and give it at death, they get a stepped up basis. So whatever the fair market value was at the date of death, that's their basis. And they can turn around and sell it and have no capital gains tax. So if you've got a situation where you're under the limits for estate and gift tax purposes, then current gifting during lifetime doesn't make sense because you're passing on a capital gain that will disappear at death. And I see this a lot of times where people think it's a good idea to put your daughter's name on the house with you or something like that, where you're effectively gifting an asset that wouldn't be taxed if you waited till death, and that will be subject to income tax, capital gains tax, if you wait until do it during your lifetime. So that's another consideration. And for some people, that stepped up basis is much more important than the estate tax because of the high dollar limit at this time. So two competing interests there, two different rules. So keep that in mind. And of course, because we can't do anything this time of year without considering the election, Harris, I researched this last week when I was putting together this presentation, and I got differing things, which again is kind of typical for our times right now, is don't trust anything on the media, right? So per Kiplinger, which is a pretty trusted source in the tax business, Harris has stayed silent and hasn't come out with any official estate tax recommendations. A lot of other sources, several other sources, have said that Harris endorsed this Warren-Cleaver proposal that came out a year or two ago. And the Warren-Harris proposal was going to decrease the exemption, which is currently $13.6 million, down to only $3.5 million per person. So a lot more people would owe estate tax or gift tax, and they would increase the maximum rate from 40% to 55%. So, you know, and the estate tax is not a big money maker, or doesn't bring in a lot of money for the government. It's not a very important budget factor. And then the more important thing that's been thrown out there is to tax unrealized gains when there's a transfer of wealth. So, you know, so say you've got 10% interest in your private business and it's got a high appreciation. If you were to choose to gift that to your kids, you would pay tax on that gain at the time of the gift. So again, you don't have to come up with more funds to pay that tax. The one change there is that they would get stepped up basis in every case, gift and bequest. So that's something that's out there, may have changes. I personally don't think that they bother doing any changes there, because yes, it hits the rich people, which the Democrats like to do, but it doesn't raise much money, so it's probably not worth the fight. And then on the other hand, Trump has said that he'd make the high exemption amount permanent, that we wouldn't have the sunset. So that's what he said about it. And as I said at the very beginning, most people will not need to worry about estate tax unless there's some radical changes in the exemption amount, that kind of stuff. But everybody needs to worry about, you know, the basic, what's going to happen at my death. You know, it's the considerate thing to do for your heirs and your family. So everybody should consider having a will, which a will says, I want my assets to go here on my death. This is my directions at my death. Power of attorney, which gives somebody else the right to act for you during your lifetime if you're incapacitated. Medical power of attorney, and most people are probably familiar with that because the hospitals pretty much require them. They give somebody else the power to say what happens when you're not able to say for medical purposes. And then some easier ways to do it are these transfer on death, TOD directives. Most investment accounts, pretty much all investment accounts, bank accounts, car titles, that kind of stuff, you can put a transfer on death directive in the title, in the ownership. You know, I, Ann Treasure, own this asset. Upon my death, it should go to Tim Treasure. You know, and that's probably the easiest way to make things go where you want them to go upon your death automatically. Don't have to go to probate, you know, don't need a document. You know, the hard part is that doesn't apply to each and every asset. And your real estate is probably already owned if you're a husband and wife in a form of the TOD. Most jointly owned real estate between spouses are tenancy by the entirety with the right of survivorship, so it automatically goes to the surviving spouse. So the TOD transfers are an easy way to get things done, but hard to make sure that you get everything. So you probably need a will as well. You know, and the downside about using a will to transfer your estate is that it has to go through the probate process, which means the probate court is going to oversee the transfer of the assets and make sure that the directions in the will have been followed, which can be a long, drawn out process, expensive with the legal fees, that kind of thing. So a lot of people want to avoid probate. And one way to avoid probate is, well, one way is to make sure everything's got a TOD on it, but that's hard to do. So another way, and that it provides other useful directions and management too, is to use a living trust. And there's lots of other names: living trust, revocable trust. And basically you're going to form a trust, which is a legal entity, and it's going to have several different sections. It's going to say, during my lifetime, I have the right to take anything out and to revoke this. I have the right to all the income. I can do basically anything I want during my lifetime. Then you move to the next paragraph and it says, if I should become incapacitated, do this. And then it says, if I survive my wife, if my wife survives me upon my death, do this. And then it says, if I survive my wife and, upon my death, do this. So it basically takes the place of the will for all those assets that are in the trust, and says what happens to them under those different circumstances. So you can avoid probate. If you get all of your assets in the trust or with a TOD, you don't have to go through a probate. And you just look to the next paragraph in the trust. It can create other trusts. It can, you can basically have any type of directions within, legal limits, in the one document. So a lot of people have the revocable trusts. It also is helpful for liability purposes. If your assets are in your trust and you get sued individually, those assets can't be touched. And, again, talk to your attorney about this. I know the basics, but it's been a long time. So, so those are some documents that you should consider having. The other thing to make sure is that, to the extent that you've got life insurance policies or IRAs or pension plans, 401ks, make sure your beneficiary designation is up to date and fits within your estate plan. So you make sure those funds are going to where you need to go. And there's all kinds of rules about distributions and RMDs and that kind of stuff that can come into play on the best beneficiary designations on those. So, and now we'll get to the fun tax part. At least I think it's fun. So the most basic concept is, if you think you're going to be in estate tax, if you think you're going to potentially owe estate tax when you die, how do you avoid it? How do you minimize it? The easiest way to do that is to get wealth out of your estate without using your exemption amount. And to do that, they use the annual exclusions to the best of your ability. So you start when you're 55 and you give, $18,000 to as many different people as you feel reasonable every single year for the next 30 years. I mean, that's a lot of money. And you can do it in a trust. Like I said, it has to be a present interest. You can do it in a trust. You can, you and your spouse do it together. So that's $36,000 per person per year. And it is indexed for inflation, so it'll go up. And that's a very easy thing to do. That can move a lot of wealth if you do it early and often. Pay everybody's tuition. If anybody's in the hospital, pay their medical bills. So take advantage of those exclusions that don't even hit the exemption amount yet. And then as far as a strategy is, don't give them cash, give them stock with the most potential for appreciation. Or if you're starting a new business, give them a small interest in the new business when it's worth nothing. So that if you hit a home run and really make it big, that wealth, the whole growth is out of your estate as well. So with the annual gifting, you do need to file a gift tax return if you exceed the exclusion amount. So you do need to have a value that you can support either through appraisal or some outside documentation. And then again, what we talked about with the basis step up, that consider if you're not going to be in a state tax position, you may want to not do any annual gifting and wait for things to transfer at death and avoid the capital gains on those. Again, with homes and real estate, I think that's probably one of the best strategies. It really depends on where you are personally. And then if you know you're going to be in the estate tax position, there's some really creative people out there that have come up with some very slick, not slick, complex and ingenious trusts to transfer wealth with a minimal use of your annual exclusion or with your exemption amount. One of them is this intentionally defective grantor trust. And you see this most of the time for an S corporation interest. And what happens is you form this trust, and it's called an intentionally defective grantor trust because it's designed to be a completed transfer for estate and gift tax purposes. In other words, it's a gift. And you got to report it on a gift tax return if you give more than the exemption, the exclusion amount. But for income tax purposes, it's what's considered a grantor type trust. And a grantor type trust means that the person who created it, the grantor, has retained some sort of control or power, a specified power. A lot of times you see a power to substitute assets during their lifetime. And by reason of keeping that power, they are now considered the owner for income tax purposes, but only for income tax purposes, not for estate and gift tax purposes. So that's what they mean by intentionally defective. They've made it so it's not a completed gift for income tax purposes. And how this is usually used is you create this trust, usually with a fairly large, a lot of some cash. And then you have the trust buy the S corporation stock from the individual shareholder for a note to be paid over 10 years. And each year when the note payment is due, the S corporation has, gone about its business, made its money, and makes a distribution to the owner, which is the trust because it's bought it. The trust gets the distribution from the S corporation, turns around and say, hey, I owe the shareholder, the former individual shareholder, I owe them the note payment. So they pay the note, and then the grantor, the individual, has to pay tax on the S corporation gain because the trust doesn't really exist for income tax purposes, but they have the funds to do it because of the note payment. And at the end of the term of the note, the stock has been effectively transferred from the individual to the trust without using any of your exemption amount. So it is a very, I've seen this multiple times. There's some considerations. You got to make sure that your S corporation has got the funds to make the distributions so the trust can make the note payments. You've got to, the other kicker is that if there is a large tax liability and there hasn't been a distribution, that the grantor has to use their own funds to pay the tax, which gets those funds out of their estate. So that's something. If you've got an S corporation and it's a fairly steady S corporation that's got good cash flow, then you can consider that. One other consideration is that the S corporation has to have the ability to make the distributions. In other words, you can't use other income tax planning things to deplete the taxable income from the S corporation to where you don't have any basis in the stock, because you don't want the distribution to create a distribution in excess of basis. And that's getting kind of complex, but you've got to watch out for that and be willing to pay income tax on the S corporation earnings and not use other tax planning, such as, buying a lot of equipment or that kind of stuff to get it down to where, if the S corporation doesn't have any any taxable income, you may not have basis, and the distribution could create a problem. So that's something to consider. And you really, in each of these situations, there's the estate tax planning consideration, there's the income tax planning consideration, there's the cash flow side of things. So it's got to make sense from all the different considerations, all the different sides. What time is it? Okay. Another trust strategy is what's called a charitable remainder trust. So if you're planning to give a large bequest to charity at your death, you may want to consider a charitable remainder trust, because basically the idea in this trust is that only the remainder, in other words, at the end, the assets go to charity. And during your lifetime or a specific term, the income comes back to the grantor. So you say, okay, I've got $1 million of stock. My basis in this stock is only 200,000. So there's a potential gain of 800,000 that you'd have to pay tax on if you weren't going to sell it, which would deplete the amount that you could invest for retirement purposes. If instead you donated the stock to a charitable remainder trust, you would retain the income interest for that. And there's two types of income interest. There's either a unit trust, which is a fixed percentage of the fair market value of the assets, or an annuity trust, which is a fixed dollar amount. So you'd be getting this stream of income, and at the end of the term or at your death, the assets would go to charity, like they were going to go at your death anyway. But the other benefit is that once you transfer the stock, the trust is a tax-exempt entity. So the trust can sell the stock and invest the full amount of the proceeds without any income tax on it. So now you've got the full $1 million to earn money for retirement purposes, instead of just the net amount after tax. And there are some more sophisticated rules that allow you to kind of tailor the income under some circumstances. You can gift the income interest, if you want somebody else to have the income stream. So if you are planning to give to charity anyway, then a charitable remainder trust is something to consider. SLATs are spousal lifetime access trust. And this basically allows you to give money during your lifetime to your spouse. It could be used for your spouse's benefit. And it can be used, this is the type of trust that I see most often that couples are using to use up their $13 million exemption amount. So it's irrevocable. You can't take it back. The spouse is the beneficiary. The funds can be used for the spouse's benefit during their lifetime. And there's some different ways you can define what the uses can be when it can be taken out for the spouse's purposes. If the spouse is the trustee for themselves, then you've got to have some more specific language saying, I can take it out for this purpose, and only this purpose. Health, welfare, you've seen the standard language. If you have an independent trustee, they can have more discretion, and have more different, broader discretionary rights on what they can make distributions for the spouse. The spouse has the right to appoint the assets, so they can give it to whoever they want to in their death, but most of the time it's already specified to go to the kids and grandkids upon the spouse's death. So basically you've given it away. You've used your $13 million instead of losing it, but it's still in the family. It's still there for their use. And the only complications you get are, what happens if you get divorced? What happens if, you're the first to die and your spouse remarries, that kind of thing. So there are ways to plan around those kind of things, and provide some more protections that it stays in the family. But again, this is the most common thing that I've seen as a way of doing a current gift and keeping things in the family for your spouse's benefit and still taking advantage of the $13 million and getting it out of your estate. One kicker on this is, you'll see, both spouses have their 13 million to use up. You can't have exact mirror trusts for the husband and wife saying, I give you this and you give me this. The IRS would look at that as you really haven't given anything because you've each got what you started out with. So what they recommend is to, do slightly different timing and also very slightly different terms. So they're not exact mirrors of each other. To get around that potential that the IRS will ignore the trusts. And as I said, there are so many different types of trusts out there and so many different ways of gifting. Some other ones that I've seen over the years are installment notes, where you set it up where, okay, I'm going to buy this house for my child, and there's going to be a mortgage on the home, so they're obligated to pay me $18,000 a year. And then every year you're going to notify them that I have hereby forgiven your obligation to pay me the $18,000. It's under the exemption amount. You do it for right amount of years. The mortgage is paid off, and so you've given them the house. So that's one way of doing it. And that can come in handy, for lower dollar amounts. It's kind of an easy way to do things. You can have an installment note where, during your lifetime, you're forgiving it each year, and then you can have it to where it automatically cancels at death. So that can be considered a gift under some circumstances. So you got to be more careful with that one. A grantor retained annuity trust is very similar to a charitable remainder annuity trust, but instead of the remainder going to a charity, the remainder goes to your heirs. So in effect, you are retaining an income interest, and the remainder goes to your heirs. So the only thing you've gifted is the remainder. And mathematically, if the way these things are valued are based on the IRS interest rates and the rates of return. So there's if you've got a lot of wealth, I've seen it where they do sequential grats, where they've done that mathematics to where they use the actual remainder interest is very small, and if the investment and the growth of the remainder is higher than what the IRS interest rate that was used to value it was, you can move wealth by doing a series of grats. The kicker is for a grat is you've got to outlive the term for it to be a completed transfer. Because during your lifetime, when you've got the income interest, it comes back into your estate. But if you do, a series of 3-year grats at the right interest rate and your actual assets are growing bigger than that, then there's a remainder to give back that goes to the heirs. That can be a way that, with big dollars amounts, I've seen that used. And then there's also charitable lead trusts, which are the opposite of a charitable remainder trust. With a charitable lead trust, you're giving the income stream to the charity, and the remainder goes to your heirs or reverts back to you, but generally to your heirs is what you see it. And like the charitable remainder trust, you get a current income tax deduction when you set this up. So you say, okay, I'm going to put $3 million in trust for a term of 10 years. And charity is going to get the income from that amount during that 10-year period. And then at the end of the 10-year period, the funds are going to go to my heirs. So you've got an income tax benefit, you've done a good thing for charity, and you've transferred the wealth to your heirs. So those are some of the other things that can be considered. Those are the basics of estate tax. Please let me know if you got any questions. And now I am going to turn things over to Dave.
Thanks, Ann. All right. You may want to.
Excuse me, Ann. This is Jerry Cow. I did have one question.
Sure.
The documents needed at time of death. You said will, power of attorney, medical power of attorney, and a transfer of death directive. And then you said living in a revocable trust. And you said the only one that would avoid probate is the living and revocable trust. Is that true?
Well, the TOD can, so if you own three things, you have a checking account, an investment account, and an IRA. If you make sure that you've got a TOD on the investment account, the checking account, and a designated beneficiary in your IRA, nothing is going to go through probate. If you've also got a house and furniture and artwork and everything else, put all that in a trust and then you can avoid probate. But if you don't do, every asset has to have some sort of direction. And if you don't have a direction on the specific asset, then the will is going to say, give it to so-and-so, it's got to go through probate, or put it in a trust where the trust has directions.
Okay, so the three things you said on the TOD was a checking account. What else?
Well, you can do TODs on almost any kind of
Anything.
asset. Checking, investment. I've seen it on a car. I've seen it on partnership interests. So that's a question for your attorney, but you can do it with a lot of different types of assets.
Okay, so done correctly, a TOD or a living revocable trust, either one of those could avoid probate.
Right. The trust will capture, the trust is a single document. You've got to make sure you transfer all the assets into the trust.
Okay.
But you can always add to it, that kind of stuff. Whereas a TOD, it's got to be each and every individual asset and, make sure you don't miss anything. I've seen probate for, I forgot one car, that kind of thing. So.
Right. Okay. All right. Okay. Thank you.
All right. Any other questions? All right. Let me introduce myself. My name is Dave Reiniger. I am a certified financial planner. And like Ann, I have actually been doing this for 40 years now. So it's been a wild journey. I smile when I listening to all the estate techniques and everything else, because in my 40 years, I think I've seen 35 tax law changes and estate law changes. So it's important to stay on top of all that. And next year, there's some big tax law changes coming next year. So stay tuned, and it's going to be a fun ride. So Jacob asked me to talk a little bit about Social Security to benefit you. So Social Security can be very, very encompassing. There's a lot of nuances. There's a lot of simple different directions you can go with Social Security between, how to plan for you and your spouse, what happens if you die first or your spouse dies first, what happens if you become disabled. There's a lot of nuances to Social Security and how it goes. So when we get done, by the time I get done here with my little 15 minutes, I'm not going to be able to go into all the nuances, but I'm going to give you a direction on where I think is a really good place to start with this. So some of the number one questions I get is, why should I even think Social Security is not going to be here for me, right? And, last week I was in front of 200 employees, and we were talking about retirement income, and I just asked, right, out of you 200, how many people think Social Security is going to be here? And only about 25% of them raised their hand, which I thought was rather scary. And there's a lot of misconception what people don't know about Social Security. So I thought I'd start off just with a little bit of a quiz and see to help you understand really what Social Security basically is going to do for us. So my first question, on the average, what percentage of income does Social Security currently replace? And there's, it'll replace 100% of your income, 70 or 40. The actual answer is 40%. So it's not, Social Security was never designed to replace all of our Social Security, all of our income at retirement. It is just a piece of that overall planning. As a certified financial planner, as you can imagine, doing this 40 years, we work with a lot of people in their 60s, 70s, and we're realizing that Social Security isn't going to pay them as much as they thought it was. So we have to look at other sources to help them get their money saved up. What's the average monthly Social Security check right now? Well, the answer to that is $1,782. So, you know, it generates enough to maybe pay your real estate tax or to maybe go out to dinner, you know, for the year or something like that. So again, it's not a big check, but it's different for other people, right? The more money you make, the bigger the check you can get, but also it's the lower the amount of replacement it's done. So the next question, if you were born after 1959, when can you receive full Social Security check? And that age is 67. That went up when Reagan did a massive Social Security update back in the 80s. You know, and back then I was in my 20s, and I hear, Reagan raised Social Security age from 65 to 67. You know, I was 20s. What does that mean to me? You know, I don't, now that I'm 64, yeah, I kind of wish it was at 65 where I could start pulling this thing out. But the reality is they raised it to protect Social Security for the long run, and we'll talk about it. And the other question we get a lot of, hey, is my Social Security check, is it taxable? And is yes all of it, no none of it, or maybe? Well, the answer there is maybe. Depending upon how much money you make in retirement off of investments, or if you have a part-time job, some of it may only be taxed at 50%, and some of it may be taxed at 85%. So the reality is based upon how much other income you're making will dictate how much of that Social Security check is taxed from that standpoint. Also, for those of us still working, remember Social Security is a pay-as-you-go program. So really everybody making money, they're going to pay money into Social Security up to $168,600. So once your income is over 160, almost 169,000, they don't take Social Security out anymore. And for those of you who are small businesses, you realize they have to pay about 7.5%, and you as a business owner have to pay 7.5%. So 15% of our income is actually going away to fund this Social Security. Well, what's going on right now is that the baby boomers have now arrived. All the baby boomers are now receiving Social Security, and what's happening is the amount of money coming in from all the workers is not enough to pay for all the money that's going out for the baby boomers. So you might be hearing that Social Security is going to be running out of money in 2035. So we'll talk about that here in a little bit. But the reality is it's never going to go away, right? Social Security will always be here. If they run out of money right now, and they don't do anything, if Congress doesn't do anything between now and 2035, so its projected amount is that your Social Security check will be reduced by 25%. I don't know of an elected official that can honestly face you face to face with a 25% drop in paycheck because they didn't do anything. There is a lot of push. You know, I'm part of a retirement reform committee in my association, and we went to Washington back in August, and we talked to congressmen of Jim Jordan, and we talked to J.D. Vance's staff, we talked to Sherrod Brown's staff, Congressman Beatty's staff. We talked to all these staff, and everybody knows that there's a problem. They are going to address it. It is going to be fixed. We just don't know what that mindset is. From what we're hearing, depending upon what the election results will dictate where some of these corrections are going to occur. For a peace of mind, to kind of give you an idea, one of the things they're talking about doing is raising the 168,600. So having more people pay more into the system. Biden also talked about leaving it there at 168.6, but if you make more than 400, then you start putting more money into Social Security. You know, That's a small piece of how to fix it. They're talking raising retirement age from 67 to 68 or 69 because younger people are going to be living longer. That fixes a big percentage of the problem. And right now, everybody gets raises every year based on the cost of living adjustment that is coming out from a Social Security check. And that's really what hurts the long-term structure of Social Security, because in 2022, everybody got a 9% raise because inflation was at 9%. So therein lies some of the problem with that. And so now one of the things they're looking at an alternative cost of living inflation gauge, and that won't increase it as much. So there are some fixes out there. I hope they act sooner than later. The sooner you act, the better off it'll be. My mindset here is, and everything we're hearing is, if you were born 1960 or later, maybe even 1955 or later, they're really not going to have any impact on your own Social Security check. The Democrats are talking about imposing a means testing, which means if you have done the right thing, accumulating a lot of money, and you have good income in retirement, then you don't need as much Social Security check. I don't know how that's going to fly, because we've been paying as much into Social Security as everybody else. So we'll see, you know, as things come by. I'm sure Whalen will tell the clients, and we tell our clients, hey, here's what's coming down the pike and what we need to be worried about. So they changed the rules back in the mid-'80s. So anybody born in 1955, they're now full retirement age is 66 and 2 months. And so they've gradually every year from 55, from 56 all the way to 59, they give you a couple more months before you have to wait. And then anybody born 1960 after, you have to be 67 before you can turn it on. Now, there's a lot of strategies that we work with people on what's the best way to do this. You can turn your Social Security check on as early as 62. But if you do that, you get 70%, you only get 70% of your normal benefit amount. And so turning it on early generally does not make sense, especially if you're going to continue to work. Social Security has implemented a work program in here that if you're working and you're making more than, and I'm sorry, I can't remember off the top of my head, but it's something like $25,000. Anything over and above that, it lowers your Social Security check by making more than that. So we haven't found a case, very rare cases, that turning your Social Security check on early makes any sense. It does if you have some health issues, you're struggling paycheck to paycheck and you can't survive without turning it on early. So there might be some planning strategies to turn it on early. But if you've done a good job in like saving in a 401k or saving in an investment account, it might behoove you to wait till your normal retirement age, because once you turn 67, for those of us born 1960 or later, you can make as much money as you want to. You can make $250,000 and turn your Social Security check on, and it will have zero impact on your Social Security check. There's also, the longer you wait, you get an 8% raise every year you wait up until age 70. And so, you know, if you wait until 70 to turn you on, you get 124% of what your benefit would have been had you waited till 67. So some planning strategies for you. If it's you, and it's just you, is it better to turn it on at 67? And I'm assuming everybody was born, you know, after 1960. So if it's you and it's just you, you're single, you don't have any worries about, the question is, are you going to work from 67 to 70? And if so, you don't need this check, then delay it. If you have any health issues, maybe turn it on at 67, even if you're still working. The bigger planning strategies, however, work is if you're married and you and your spouse are entitled to different benefits. And everybody's, as long as you've worked for 10 straight quarters, you are 10 quarters over your working career, did I say 10 years, so 40 quarters. As long as you have that, you're going to get a Social Security check. And then that benefit has to be coordinated with your spouse's benefit be coordinated with yours. And there are some really interesting strategies to get a maximum out of your Social Security check. One classic strategy that has worked a lot is if you're married, the spouse who has the smallest Social Security check, you turn that on at the normal retirement age. And you delay the larger Social Security check until age 70. Why? Because when we do planning for couples, statistics know that there's a high likelihood that one or the two of you are going to live into your late 80s, early 90s. So when the first person passes away, the survivor gets the larger of the two Social Security checks. So if you can afford to wait on the larger of the two Social Security checks to 70, after that, it's going to increase on the cost of living. And then when the first person passes away, they get that larger of the two Social Security checks. So that's kind of some long-term planning strategies. Others say, we don't think Social Security is going to be here for the next 20 years, so let's turn it on now and let's be done with it, right? Everybody's different. One of the things we love talking to Social Security people about their Social Security is because everybody's different. They all have their own personal stories. They all have their own personal reasons why they might want to turn it on now. And the key with all this is that we know Social Security, we can count on it. We know it's going to be there. It is coming out of the government, out of a trust fund that you and I have funded over our working careers. Yes, it's going to start coming down because us baby boomers, and I'm at the end of the baby boomers, are now coming up to full Social Security. And so when Social Security first started, there was like 19 people working for everybody in retirement. Now here in the coming into the late 2020s, it's almost down to 2 people working for everybody in retirement. So we know changes need to be made. It's really important that our elected officials get their act together and start putting forward. So Social Security is a moving topic. You know, it's always important to know where your benefits are. You know, keep a big picture in perspective. And what I mean by that is look at your other assets. Remember, Social Security was originally only designed to provide 40% of your retirement income. So look at your other assets. What should we do early? You know, if we like the idea of waiting till 70 because you're healthy, then pull money out of your 401ks or IRAs or Roth accounts from 67 to 70, and then turn Social Security on at 70 and lower the withdrawals out of the other stuff. Again, with a couple, there's even more fund planning opportunities that you can do. And so there are financial advisors out there with financial planning designations can walk through you all this. There's also a lot of tools on retirement planning that can show you how to maximize retirement benefits, pension benefits, Social Security benefits. And even on the Social Security website, ssa.gov/planners, they've got some great tools to help you go through your own personal scenario and what's going to happen. I personally have been on the phone with Social Security with clients, and they are very knowledgeable. The people that you get a hold of, when you can get a hold of them, you might wait an hour or so, but they really have a true understanding, and they pull up your accounts and they will walk through different scenarios for you specifically. So we really help and as you get late 50s, it's probably a good idea that you log on to the website and get where you want to be. Make sure you understand where you want to be with this. Planning with your spouse is important because this is a journey. You guys have been working together over your working careers. Now you're going to be retired together and on a permanent vacation. So knowing where your money is coming from, helping you decide together will help you understand that. And you know where you're going to retire is important. If you're going to be in a nice, inexpensive but nice small town, that's going to be less expensive than living in New York City. So this is all part of that Social Security and how it plays into it. When to take that Social Security check to maximize it. And they have the survivor benefits on there. So the other part of this is there's 2 pieces to the benefits. One is the living benefits. The spouse gets the larger of their Social Security check or half of the larger check, right? So that's while both of you are alive. So if we have one Like my spouse is going to get a check for about $900 a month. And she hasn't been working in 35 years. She's been a stay-at-home mom. So, but before that, now her Social Security says it could be $900 a month. My Social Security check is going to be about $3,000 a month. So when I turn on my Social Security check, she'll be entitled to half of mine because it's larger than hers. So there's living benefits about collecting this type of money. The death benefits are the survivor gets the larger of the two, they don't get to keep both. So understanding that basic concept of payouts really, really will help. Where should you go? The one takeaway from here, if you don't take anything else away from this, and again, this presentation is available to you, is if you haven't done it already, go to ssa.gov. That's a Social Security website. And then there's a little link up in the upper right corner that says My Social Security. If you click on that link, it'll ask you to set up your own profile. That profile, you put in your username, password. They're going to ask you some clarifying questions to make sure you are who you say you are. And then they will give you what your projected benefit is at 67, at 70, at 62. And they'll go through spousal benefits and disability benefits. And they will actually show you the different income options that you have available. And if you do that for your spouse, it gives them both of them. What Social Security hasn't done yet is combine, but realize that both of you are spouses. So they haven't really put a good thing together. That's why you need to talk to somebody about it or work with a financial planner who has some understanding of this. So if you can get in there and create your own account, the other thing you need to double check on the myssa.gov once you get into my account is your income history. I double check mine every year, right? Just to be careful, because Social Security's benefit is based upon your income over your best 10 years. Well, if you're in your 60s, there's a high likelihood your income is going to be a lot higher in your 60s than it was in the 50s, 40s, or 30s. So that fictitious report that we get every year once we turn 60 is going to look different when you actually retire, especially if your income is higher in those particular years. But if you log into that ssa.gov and you open up your own account, you can verify the income they have on there is correct. We did this with a company and we had a bunch of employees go in, open up their ssa.gov, and it found out they were missing 3 years of income. And that was because payroll never got it submitted to Social Security. So we had to go and get that fixed. So it's always important to keep tabs because this is your pension. You know, whether you've been funding it your whole working career. And I believe deep in my heart, it will be there and there will be some people who make decisions, make the right way. So with that, that's my story. I'm sticking to it. And again, if you go into if you go into ssa.gov and open up your account, you can see your own statements. So if you have any questions for your own personal situation, by all means, give me a call or just shoot me an email. Any questions?
I was going to say, on that note, so there was some questions submitted to our chat. So Mark does ask, does the yearly gift of $18,000 given over multiple years reduce the one-time transfer of $13.6 million? He also asked to clarify, is that just money or can it be in real estate, LLCs, or businesses?
Yeah, the annual exclusion gifts do not affect your lifetime exemption. So you can give the $18,000 every single year to as many different people as you want every year, and it does not affect your 13 million. As far as the cash, no. What I'm talking is fair market value transferred. Any type of asset, fair market value transferred is what gets measured for gift tax purposes and estate tax purposes.
Perfect. Kathy also asked, so her and her sons bought a house together and they're all of their names are on the title. Upon her death, are they going to be taxed?
So if you've got two sons and you bought a house together for $300,000, equal shares, you each have a basis of $100,000 in your interest, right? If you die and the house is worth $600,000, they're going to inherit your share at the fair market value at the date of death, that's 200,000 instead of the 100 that you bought it for. Their basis in their own shares that they've owned since the purchase remain at the 100,000. So if you sell the property, your capital gain is going to be based on that kind of mixed basis amount. Whereas like if you'd had the house 100% you, then at your death, they'd get a full fair market value at date of death and no capital gains. So you've got to look at the various interests and what's being transferred at death and what's not to determine what the basis is.
And then one last question. What is a strategy for avoiding income tax on IRAs?
There's really not a whole lot of ways to avoid the income tax. Somebody's going to pay on it regardless sooner or later. So the strategy with IRAs is generally to defer it as long as you possibly can. So, the longer that the funds can grow tax-free within the IRA is to your benefit. But it's always going to be taxed. We're talking about regular traditional IRAs and not Roths. It's going to be taxed when it comes out. So the idea is to delay it as long as possible. And there's been some changes in that area over the last 3 or 4 years. The Secure Act and the Secure Act 2. You used to get you used to be able to stretch the distributions out over a beneficiary's lifetime. Now there's generally a 10-year term, but these are strict generalities. There are very complicated rules on inherited IRAs and required minimum distribution, but they're generally looking to shorten the time period that you need to take it out, as opposed to being able to stretch it out longer. You used to have what's called a stretch IRA, and that's the lifetime of the beneficiary, and that's restricted now.
There is one, not to interrupt, but there is one way to take money out of your IRA and not pay any tax on it whatsoever, and that's through a qualified charitable distribution once you turn 70 and a half. So that may go away with Trump's tax cuts, but
yeah,
right now
I kind of look at that as a better way of making a charitable contribution if you've got the right circumstances.
Gotcha. And David, I believe I have a question for you from Kurt. How accurate has the estimated payment showing on the SSA website been historically?
they've been very accurate, unless you are in those really, really high income levels just before you take your Social Security income. If your Social Security income's been pretty consistent and just gradual little increases over the years, then they're going to be very accurate. But if all of a sudden in your 60s your income goes from 100 grand a year to 400 grand a year, then all of a sudden it's going to probably make it raise a little bit more than normal. I think that's our story, and we're sticking to it.
I think so.
Yeah,
well,
thank you very much.
Yes, thank you guys. I really appreciate the presentation. I'm quite young and way far from retirement or planning my estate, but it's good information to have in my mind. Although I'll probably turn to Ann or Eve when I get there.
Yeah, but we need you
around,
to keep
right?
we need you to keep working to fund our Social Security.
Oh, I'll keep working.
Give me a call
All right, everybody.
if you have any questions. Thanks.
Thank you guys.